Hi, and welcome to Creepy Crime Story, where the darkest truths aren't imagined, they're real. A quiet weekday morning in Cranston, Rhode Island. An apartment on Bayview Avenue doesn't answer texts, calls, or the door. Friends request a welfare check. Officers enter. Inside they find a 29-year-old woman, Lauren ISC, unresponsive. The room is still. There's no chaos that screams break-in, no obvious ransacking. What stands out is proximity. Whatever happened here, it happened close. From the start, investigators treat it as a suspicious death. The scene is documented by sequence, entry photos, wide to tight, then evidence tags. They protect likely transfer points, doorknobs, the window line, the kitchen counter edge. First responders note skin color and position, then step back. Medical examiners take over. Early indicators point to strangulation, the neck shows compatible signs. That narrows the field. This isn't distance violence. This is hands-on. Neighbors are canvassed immediately. One account mentions a predawn disturbance the previous morning, someone at the windows, a knock that didn't become a complaint but did become a memory. Around 6 a.m., a man allegedly asked a simple question about Lauren's private life, whether she'd begun seeing someone else, and left. In towns like this, murders aren't just crimes, they tear at the fabric of a quiet community. An investigator writes in his log, the data aligned too cleanly. Sometimes that was the problem. Detectives map the last 48 hours without speculating. They look at door traffic, delivery timestamps, rideshare pings in the corridor, and the apartment's power and device use. If phones were active, when did they go dark? If messages were sent, were they routine or stressed? They secure Lauren's devices for lawful extraction, duplicate them, and preserve original media to keep the chain of custody intact. Friends supply the life context, work plans, a recent breakup, and a prior incident where police were called when she tried to retrieve personal items. That entry belongs in the file because it establishes escalation risk. It does not answer the ultimate question. Back at the apartment, the forensic team takes swabs from high-frequency touch zones and photographs any compression artifacts that might show where a struggle began and ended. No one announces a theory at the doorway. Procedure matters. The cause of death will be confirmed by autopsy. The timeline will be pinned by corroborated timestamps, not by guesswork. The working theory is simple: a targeted assault by someone with access or determination, executed within a narrow window the morning March 13, 2019. Lauren's name enters the system with the respect due of victim, age, address, next of kin notified. Her life is not a prop, it is the center. Viewers sometimes ask why we move slowly here. The reason is that speed creates mistakes. This case will rely on a tight chain, scene findings, neighbor statements about the early morning visit the day before, and any admissions that might surface once a suspect is located. For now, there is no suspect named on camera. Only a pattern beginning to show itself. The clock starts 2 days out. To keep this clean, detectives anchor every minute they can verify and ignore noise. They collect Lauren ISC's recent communications under warrant, pull call detail records, and image her phone so analysts can review without altering the original. They check building traffic, package scans, delivery timestamps, and ride logs in the neighborhood corridor. The goal is simple: identify who had reason, opportunity, and access in a narrow window that ends the morning of March 13, 2019. Neighbors remember a disturbance the day before the homicide. Predawn. Knocking at Lauren's windows. Around 6 a.m., a man asks a direct question about her private life, whether she's seeing someone, then leaves without incident. That matters because it puts a person of interest at the property within 24 hours of the attack. It also gives detectives a live voice to compare against future statements. In towns like this, murders aren't just crimes, they tear at the fabric of a quiet community. Here, the fabric shows a snag the day before everything breaks. Investigators build a simple ladder of time. Step 1. Establish Lauren's confirmed activity in the 24 hours before discovery. Friends report routine messages that stop abruptly. Work obligations go unmet. There's no evidence she left the apartment voluntarily overnight. No rideshare pickups tied to her accounts. No outgoing payments that would suggest an unplanned trip. The apartment becomes more than a location, it is the fixed point everything else has to orbit. Step 2. Eliminate strangers. Entry points show no obvious forced defeat. The door hardware is consistent with ordinary use. Windows present no broken latch or pry. That doesn't prove anything by itself, but it pushes the hypothesis toward a visitor who was either expected, persistent, or both. The data aligned too cleanly. Sometimes that was the problem. When a scene appears intact, you have to test every assumption, access codes, spare keys, prior visits, and any pattern of uninvited returns. Step 3. Sort contact chains. Detectives flag the period after a recent breakup as a risk window. That's not a narrative flourish, it's a known domestic violence pattern. A police call weeks earlier, when Lauren tried to collect personal items, is documented in the record. It establishes escalation pressure without requiring speculation about motive. Interviewers speak with friends and family to confirm tone and content. Were messages calm? Was she concerned about anyone? Did she alter routines, change locks, or mention a plan to meet someone? Each answer either narrows or widens the field. Digital forensics stays restrained and methodical. Examiners copy Lauren's device, preserve application metadata that shows when chats were sent, opened, or failed, and correlate any last active indicators with router logs from the building. If a neighbor's camera captured corridor movement, analysts sync the timestamps against the phone timeline. The idea is not to make the electronics the story, it's to let them confirm or contradict what people remember. In this case, the early morning visit on March 12th emerges as the cleanest witness anchor. It precedes the homicide and speaks to intent. Someone was checking, probing, or asserting control. Back out at Bayview Avenue, a second canvas asks a narrow question. Did anyone see the same man return the following morning? Negative citing doesn't end the line, it just moves weight back to the apartment and to the people who had reason to be there. Meanwhile, friends give consistent statements about Lauren's schedule and about the normalcy of her last full day. Nothing suggests she planned to leave with anyone, at any time, for any reason. The working window tightens. The victim is last known alive inside the residence. The body is found there. No credible evidence places her elsewhere that night. That combination lets the medical examiner's estimate of time of death carry more weight when paired with the neighbor's timeline. The case advances without theatrics, a likely return visit on March 13th, a close contact assault, and no credible alternative path in or out that points to a stranger. Viewers often ask where the twist is. In real investigations, the twist is discipline. You execute the basics so well that the noise falls away. There's a human line that runs through this. Lauren's friends did the right thing by reporting concern quickly. In many communities, that's the intervention point that changes outcomes. Here, the speed preserved the scene, the devices, and the timeline. Those are the three legs that will hold the case up later, no guesswork required. The scene is cleared for a full workup. Technicians move in with a single objective: document, preserve, and let the evidence speak. They photograph from entry to endpoint, then collect trace from the most likely transfer spots: door hardware, the window line previously noted by neighbors, the kitchen counter edge, and the pathway to where Lauren ISE, 29, is found. No theory gets priority over sequence. The log shows who touched what, when, and why. The medical examiner takes custody and issues a preliminary determination: death by strangulation. That conclusion doesn't rely on a single sign, it's an overall pattern. It is also consistent with a narrow window on the morning of March 13, 2019. This matters for one reason: it ties time of death to the same window the timeline unit has been building. When clocks match, witness account, digital cutoff, and medical estimate, the case moves forward without guesswork. Examiners run a limited field test for foreign touch DNA on high-probability surfaces and preserve additional swabs for the state lab. They dust selective areas for latent prints that could show contact unique to the event, not just household background. Anything recovered is packaged with chain of custody seals. Anything not recovered still has value, because absence can tell you how an offender moved. If there's no forced entry and no obvious ransack, then the offender likely knew how to get in or had the determination to return until a door opened. That doesn't name anyone, but it shrinks the universe. Devices are imaged under warrant. Analysts confirm the last confirmed communications from Lauren and plot the period where her phone stops showing normal user activity. They do not need exotic tools. Standard forensic suites can map texting windows, app openings, and idle stretches that suggest when the device was no longer in her hands. Router logs from the building, if available, help align power on versus active use. The goal is not to dramatize the electronics, it's to certify when communication ceased relative to the medical examiner's clock. Back to the room. There is no stage display that would muddy manner of death. The posture and immediate surroundings suggest an assault that happened fast and close. Investigators note compression-compatible findings the examiner will later formalize. That gives prosecutors something crucial months later, proof of intent and a mechanism that meets the threshold for first-degree murder under Rhode Island law when paired with relationship evidence. You don't need flowery language for that. You need certified findings and a clear bridge from science to statute. Neighbors provide a second layer. The early morning window incident on March 12th and the 6 a.m. question about Lauren's dating status did not produce a police report at the time, but they become sworn statements now. Each is timestamped by the interview log, matched against simple external anchors, shift changes, school runs, morning alarms. The point is reliability. One clean, specific recollection is stronger than 5 vague ones. Investigators know this and keep the canvas focused. A quick word on humanity. When a victim is killed by someone at close range, families often want definitive answers now. The lab cannot move on grief's timeline. What teams can do, and do here, is protect evidence so that when answers arrive, they hold in court. That restraint honors the victim more than any speculation. It also protects the public from bad cases. This is part of accountability that rarely makes headlines, saying less now so the facts carry more weight later. By the end of this workday, the file has 3 anchors that align: a medically supported cause of death, a time of death estimate compatible with the morning of March 13th, and a clean, consistent scene showing close contact without forced entry. Add the verified March 12th visit, and you have a sequence that points to a returning visitor rather than a passing stranger. No one is named on camera yet. The record has to be ready before the story does. For viewers who ask where community fits in, consider this: the neighbor who remembered that 6 a.m. question did more than share a detail. They supplied a time marker that helps secure a prosecution. Small facts matter. When people speak up early, cases move faster and cleaner, and families get answers rooted in proof. The physical case was strong, but cases move faster when someone talks. Within hours of Lauren ISE being found in her Bayview Avenue apartment, an acquaintance walks into the story with information detectives can't ignore. He reports that a man he knows showed up shaken and admitted killing Lauren. He provides names, times, and enough detail about the manner of death that investigators flag the statement as more than a rumor. This is the first direct bridge between the room and a person. Detectives document the friend's statement on the record, then test it against what the lab and the medical examiner have already pinned down. The friend describes close contact, no weapon, and a morning timeline. Those elements match the preliminary autopsy findings and the window investigators were already working. Importantly, he isn't guessing about the date. He places the admission on the same day officers entered the apartment. That proximity matters. People can repeat headlines, they struggle to mirror facts that aren't public yet. Next, officers locate and arrest the person named in that statement. During transport to court for arraignment, something unusual happens. He makes an incriminating statement to the sheriff's personnel escorting him. It is not prompted by questioning. It is recorded in contemporaneous notes and later sworn to in court filings. Defense teams often try to exclude statements made in custody. Voluntariness changes that calculus. When a person talks on their own, and it lines up with evidence already in hand, the prosecution's path gets clearer. After arraignment, recorded jail calls add another layer. The same individual recounts the event again, this time to someone he knows, sharing details consistent with the apartment's condition and the autopsy's direction. Corrections systems routinely warn callers that conversations are recorded. People speak anyway. Detectives pull the call logs, isolate the right recordings with counsel present, and lock them to the case file. Now there are 3 points: a same-day admission to a friend, a voluntary statement en route to court, and recorded calls that repeat core facts. When 3 sources point the same way and none of them come from law enforcement interrogation, credibility increases. At this point, for the first time, we can name the suspect on camera because the evidentiary spine supports it. The person under arrest is Michael Marapesi, 46. He is identified in filings as Lauren's former partner. The public also recognizes his last name because his late father, Frank Bobo Marapesi, was a notorious mob figure in Rhode Island decades earlier. That background may explain public interest, it does not decide guilt. What decides guilt is evidence, timeline, and admissions that survive legal scrutiny. Investigators circle back to the simplest corroboration test. Does each statement contain a fact that only the perpetrator, or someone present, would know? The friend's account speaks to the method and timing before any press conference identifies manner of death. The transport statement includes phrasing consistent with close contact assault. The jail calls mention a return to the apartment after an early morning visit the day prior, something neighbors described independently. None of these items, standing alone, would be enough. Together with the scene and the medical examiner's findings, they create a closed circuit. Prosecutors start thinking forward. Admissions are powerful at trial, but jurors want to see each one anchored. The team prepares transcripts, chain of custody for the recordings, and a clean witness list that will include the friend, the escorting sheriffs, and a custodian of records from the jail. They also prepare for the obvious defense angle, that the statements reflect remorseful exaggeration, not accuracy. That argument loses force when the language tracks with physical evidence collected before the statements were made. There is a human reality here. Cases involving intimate partners often turn on patterns of control before and after breakups. In this file, there was an incident weeks prior where Lauren sought to collect belongings and police were called. There was a neighbor's report of a predawn window disturbance and a 6 a.m. question about whether she was seeing someone. Then, according to multiple sources, there was a return to the apartment the next morning, a fatal assault, and immediate admissions. The pattern is not complicated. It is precise. When communities recognize it early, controlling behavior, surveillance questions, uninvited returns, they can intervene earlier and more safely. By the time the charging documents are finalized, the case is no longer an inference about access and opportunity. It is a story told by a room, a body, and the defendant's own words. Investigators keep their paperwork plain, dates, times, names, and quotes limited to what the record supports. Nothing extra. That restraint is a choice. It keeps the case from turning into 2 narratives, one in public and one in court. There is only one here. Once the admissions were locked to the physical record, the case moved from probable to prosecutable. Detectives briefed prosecutors with a straightforward package: cause of death established by the medical examiner as strangulation, a narrow morning window on March 13, 2019, a consistent apartment scene on Bayview Avenue, a same-day confession to a friend, a spontaneous statement during transport, and recorded custodial calls that repeated core facts. Nothing theatrical. Just pieces that fit. An arrest followed in March 2019. Officers served the warrant, documented the defendant's condition, and transferred him to intake without incident. In court soon after, prosecutors argued for detention based on 3 pillars: the seriousness of the offense, the admissions, and the domestic context pointing to escalation after a breakup. Defense counsel noted the presumption of innocence and asked the judge to consider conditions. The bench focused on risk. Violent conduct in a domestic setting, paired with multiple admissions, weighed heavily. Bail was denied. That ruling set the tone for the next phase, a slow, methodical build toward trial in Providence County Superior Court. The early hearings were procedural but important. Discovery orders kept the case clean. The state would produce transcripts of the transport statement and jail calls, certify chain of custody for audio, and provide lab reports as they finalized. Defense was granted time to review recordings and to examine whether the statements were voluntary and admissible. Because the key statements weren't the product of interrogation, suppression would be an uphill climb. The friend who first reported the confession was placed under subpoena and instructed not to discuss the matter publicly. Investigators also secured custodians of records from corrections, so no one later argued the recordings were mishandled. By late summer 2019, the defense entered a not guilty plea. On paper, that plea kept every option open. In practice, it meant the state would finish the last mile, final autopsy documentation, any touched DNA comparisons from high-probability surfaces, and formal witness prep for the neighbor who reported the early morning contact on March 12. Prosecutors don't win cases with headlines or backstory, they win by lining up witnesses who tell the same sequence the evidence already proves. Here, the sequence was steady: a window disturbance and a question about Lauren ISE's private life the day before, a morning return, a close contact homicide, and an immediate series of admissions. Outside the courthouse, the last name drew attention. Inside, it had no legal weight. Judges instruct juries that notoriety isn't evidence, and prosecutors who want to keep a verdict safe don't lean on it. What mattered was that Lauren ISE, 29, was killed in her own home in Cranston, Rhode Island, and that the person accused of killing her had, according to multiple sources, said so in his own words. The state's strategy reflected that: keep the file narrow, keep the timeline clear, and keep the proof focused on what could be cross-examined. The detention period stretched because serious cases take time. Labs run at their pace, motions are briefed and argued, calendars fill. Families sometimes read delay as indifference. It isn't. It's the system doing the unglamorous work that prevents reversals later. In this case, prosecutors repeatedly met with Lauren's family to explain the posture, why keeping certain details out of the press protected the integrity of upcoming hearings, how the statements would be presented, and what to expect before a jury ever sat. Respect shows up here, in scheduled updates, in returned calls, and the steady use of a victim's name. That matters. As trial talk became real, the court set dates. Jury selection was placed on the calendar, and both sides previewed what opening statements might look like. The state wouldn't need to promise drama. It would promise proof: the neighbor's recollection pinned to a clock, a friend repeating the words he heard the day the body was found, transport officers testifying to a voluntary statement, custodial recordings that echoed the same core facts, and the medical examiner tying injuries to intent. The defense would test each link: memory under stress, the possibility of embellishment, the reliability of correction systems, the risk of contamination at a lived-in scene. That is how the process should work. One choice stood out as the case matured. Prosecutors avoided overcharging. They didn't stack counts that could confuse jurors or create inconsistent verdicts. They charged the homicide count they believed they could prove, domestic first-degree murder, and prepared to show why the facts met the statute. The domestic designation wasn't a headline tag, it reflected the relationship between the accused and the victim. When a case rises and falls on close contact violence after a breakup, the law needs that context to be explicit. The hold continued through 2020, 2021, 2022, and 2023. Each year added hearings and status checks but did not change the spine. Witnesses remained available, recordings remained intact, and the scene remained singular: Lauren's apartment. Delay did not help the defense, it simply extended the calendar to the point where, in 2025, with jury selection imminent, decisions had to be made. What prosecutors had forecast from the start, clear admissions joined to a stable forensic and temporal backbone, had not loosened with time. If anything, it had hardened. Cases like this carry a quiet lesson. Justice isn't a race, it's a sequence. When facts are preserved and witnesses are treated with care, time works for the truth, not against it. That's how you keep one narrative from splitting into two, one for the public and one for the courtroom. Here, there was only one: what happened to Lauren ISE, and who said they did it. By early 2025, the case was trial-ready. The file wasn't dramatic, it was disciplined. Prosecutors in Providence County set jury selection for late April. They'd lead with the scene at Lauren ISE's Bayview Avenue apartment, bring the medical examiner to confirm strangulation and time of death parameters, then stack the 3 admissions in order: the same-day confession to a friend, the voluntary transport statement to sheriffs, and recorded jail calls. Each witness touched a different piece of the proof so the story wouldn't depend on any single voice. Pretrial hearings focused on what jurors would be allowed to hear. The state moved to admit the custodial recordings with a standard foundation, system warnings, recording procedures, and authenticated call logs. The defense signaled the usual challenges: context, stress, and whether phrasing could be misheard, but voluntariness favored admission. A motion in limine sought to keep the defendant's family notoriety out of trial. The judge agreed that history had no bearing on whether Lauren, 29, was killed in her Cranston home in 2019. The jury would hear about relationships and actions, not headlines from another era. Witness prep was tight. The neighbor who remembered the predawn window disturbance on March 12 and the 6 a.m. question about Lauren's dating life rehearsed testimony down to sequence and clock references. The friend who reported the same-day confession reviewed exactly what was said and when, sticking to words, not interpretations. Transport personnel refreshed notes from 2019 so their account of the unsolicited statement would match contemporaneous logs. The medical examiner streamlined language, cause, mechanism, and intent implications, no jargon that could confuse a lay panel. The goal was a straight line the jury could follow without a chart. Juror questionnaires were written to surface bias quickly. Domestic violence dynamics can polarize panels. Both sides needed people willing to judge specifics. The court's voir dire would test whether prospective jurors could separate a difficult breakup from a homicide allegation and whether admissions, especially recorded ones, would be weighed with care, not certainty. That balance matters. Juries convict on trust. Prosecutors earned trust by showing how each fact was documented before anyone spoke. As the date approached, the case posture didn't change. The apartment remained the only crime scene. The timeline stayed anchored to the morning of March 13, 2019. No new forensic twists were necessary because the spine was already strong. What changed was tactical. With a jury about to be seated, risk calculation moved from theory to reality. A trial would replay every statement in open court. The friend would testify. The transport officers would testify. The jail calls would be played. The medical findings would sit beside those words, and the pattern of control before the killing, documented by a prior police response when Lauren tried to collect belongings, would supply context the statute recognizes. Behind closed doors, counsel weighed options. Trials are public. Pleas are not performances, they are legal decisions tied to proof. When the evidence is layered, scene, autopsy, independent admissions, it leaves fewer escape ramps. A guilty verdict at trial would almost certainly mean a life sentence without the possibility of parole. A plea could reach the same destination while sparing the family testimony they didn't need to hear. Those are harsh choices, but they are real ones in violent crime courtrooms. There's a human piece that deserves a clear sentence. Lauren's family had waited since 2019 for accountability. By 2025, they had attended hearings, answered questions, and lived with a case that didn't fade. The system owed them a resolution grounded in facts, not theater. That's why the state kept the presentation narrow. No second narrative. No alternate ending. Just the evidence that would hold, whether in front of 12 jurors or a single judge. The week jury selection was scheduled became the week the trajectory shifted. We'll cover that decision next, but the setup matters. Nothing new had to be discovered to trigger the change. The record built in 2019, Lauren's apartment, the medical conclusions, and the admissions, was enough. Sometimes the pivot isn't a twist, it's a recognition that the case is trial-proof as charged. On April 24, 2025, with jury selection set to begin, the posture changed. In a Providence County Superior Court courtroom, the defendant stood with counsel and entered a guilty plea to domestic first-degree murder for the killing of Lauren ISE, 29. This was not a negotiation for a lesser label. It was an admission to the top count the state had prepared to try. Plea hearings are exact for a reason. The judge confirmed identity, competency, and understanding. Rights were read and waived on the record: the right to a jury trial, to confront witnesses, to remain silent, to force the state to prove every element beyond a reasonable doubt. Each waiver required a clear yes. The court then asked the state to state the factual basis. Prosecutors recited the timeline that had held since 2019, the Bayview Avenue apartment in Cranston, the medical examiner's conclusion of death by strangulation on the morning of March 13, 2019, and 3 separate admissions: same-day confession to a friend, a spontaneous custodial statement during transport, and recorded jail calls that repeated core facts. No embellishment. Just the pieces that would have gone to a jury in the same order. In Rhode Island, domestic first-degree murder acknowledges 2 things: a qualifying intimate partner relationship and an intentional killing meeting the statute's elements. The court asked if the defendant agreed that those facts were true. He did. The judge took care to ensure the admission was voluntary, not the product of threats or undisclosed promises, and that counsel had enough time to advise him. The transcript will read dry, but that is what protects the plea: clear questions, clear answers, and a factual basis tied to evidence already preserved. For Lauren's family, this step mattered. A plea cannot give back years, but it can stop the replay. They would not have to hear the recordings in open court or watch witnesses relive a morning that never should have happened. The state noted that the family had been consulted and that the plea aligned with the sentence they were seeking at trial. That matters in a victim-centered system. You avoid surprises at the moment when decisions are final. After accepting the plea, the judge ordered a pre-sentence investigation and set a sentencing date. The range for this offense in this context was known, and both sides understood what the state would argue for at the next hearing. The defense reserved the right to present mitigation, history, statements of remorse, any expert reporting they believed was relevant, but the plea foreclosed the central dispute. The question of guilt was no longer before the court. Only punishment remained. There is a narrow lesson in this pivot. The case did not rely on one witness or one test. It relied on aligned blocks: a single crime scene in Cranston, a cause and mechanism confirmed by the medical examiner, and admissions that came from the defendant himself without interrogation pressure. When those blocks are stable, a plea often reflects reality, not convenience. For the record, this change did not create a second narrative. It confirmed the only one the file had carried since 2019. Lauren ISE was killed in her own apartment. The person responsible admitted it in multiple contexts, and the law recognized the relationship and the intent required for first-degree murder. The next and final steps would be formal sentencing and the court's pronouncement of a term that matches the gravity of the crime. October 23, 2025, Providence County Superior Court. The file was complete, the plea was on record, and only punishment remained. The judge reviewed the evidence chain: Lauren ISE's apartment in Cranston as the sole crime scene, the medical examiner's finding of death by strangulation on the morning of March 13, 2019, and 3 independent admissions from the defendant. The ruling was direct and final: life imprisonment without the possibility of parole for Michael Marapesi, 46. No suspense, no alternate outcome, no second version of events. Sentencing is where courts put reasons on the record. The court emphasized deliberate, close-contact violence in the victim's home, a pattern of control leading into the killing, and admissions that were voluntary and corroborated. The Attorney General's office echoed that assessment. Lauren, 29, faced escalating monitoring after a breakup. Law enforcement and neighbors documented the warning signs. The case succeeded because those facts were preserved early and cleanly. Defense allocution noted remorse, but mitigation could not overcome the admissions and forensic spine. The term, life without parole, means exactly that in Rhode Island: no eligibility before a parole board, ever. The human point belongs here, stated simply. Lauren was not a headline, she was a person with a routine and a future. From 2019 to 2025, her name stayed at the center of the file. Friends who acted when contact stopped, neighbors who remembered the predawn window incident and the 6 a.m. question, and investigators who refused to speculate, each helped keep one coherent narrative from start to finish. That is how you avoid the problem viewers hate: 2 endings. This case has one. If there is a public takeaway, it is practical. Risk often spikes around separation. Uninvited returns, surveillance questions, controlling access, these are not minor dramas, they are danger signs. Early calls create documentation, preserve devices, and give prosecutors tools that stand up in court. Reporting is not only about punishment, it is about safety, record keeping, and options before violence occurs. Before we close, here's what I carry forward: when control creeps in after a breakup, uninvited visits, questions about who you see, treat it as danger, not drama. Speak up early. Document. Check on friends. In towns big or small, that's how we keep each other safe. If you're facing this, reach out to trusted people and local resources. You're not alone. What would your community strengthen: reporting, bystander action, or victim support? Tell me in the comments where you're watching from. If this story moved you or challenged you, subscribe to the channel and join us for the next case.